Hi friends, in this video we are going to deal with the important judgment titled Amar Nath versus Gian Chand and another pronounced on 28th January 2022. This judgment deals with that the protection of the original power of attorney is not necessary if the document is presented for registration by the power of attorney holder who executed the document on the strength of it. To know more about this case synopsis, please watch the video fully. The facts of the case would be that the plaintiff filed a suit for declaration by way of permanent injunction that he is the owner in possession of that property, and the mutation showing the sale in favor of the first defendant by the second defendant was null and void, and that the second defendant was not having any authority to sell the land owned by the plaintiff, and hence the defendant be restrained from interfering with the ownership and possession of the plaintiff. The plaintiff further alleged that he bona fide executed a special power of attorney in favor of second defendant for selling the property for the amount of rupees 55,000. As the negotiation fell through in view of the first defendant not being able to arrange the money, the second defendant to whom the power of attorney was executed surrendered the original to the plaintiff, and the plaintiff told the first defendant that the same stood cancelled. Thus, the second defendant could not execute the sale deed in the absence of the original power of attorney, and the sub-registrar was supposed to verify the aspect from the second defendant under sections 32, 33 and 34 of the Registration Act. The trial court dismissed the suit and the same was upheld by the first appellate court. On second appeal, the High Court observed that in view of the cancellation of the original power of attorney, the same could not be relied upon by the registering authority for the purpose of execution of the sale deed. The High Court also held that as per section 18 of the Registration Act, it was necessary for the registering authority to see the true copy of the special power of attorney. Being aggrieved, present appeal has been filed. The Supreme Court has held that Section 18A of the Registration Act contemplates the production of a true copy of a document which is sought to be got registered and not the true copy of the power of attorney. When a person empowers another to execute a document and the power of attorney acting on the power executes the document, the power of attorney holder can present the document for registration under Section 32A of the Registration Act. Section 32C deals with agents of the persons covered by Section 32A and agents of a representative or assignee falling under Section 32B. It is in respect of such an agent that there must be due authorization by a power of attorney, which in turn is to be executed and authenticated in the manner provided for in Section 33. However, the person who has actually signed the document or executed the document for the purpose of Section 32A does not require a power of attorney to present the document. When Section 32C of the Registration Act declares that a document, whether it is compulsorily or optionally registrable, is to be presented inter alia by the agent of such a person, representative or assignee, duly authorized by power of attorney, it must be executed and authenticated in the manner and hereafter mentioned immediately in the next following section. Section 33 by its very heading provides for power of attorney recognizable for the purpose of Section 32. Section 32A cannot be read with Section 33 of the Act. In other words, in a situation if a document is executed by a person, it will be open to such a person to present the document for registration through his agent. The agency can be limited to authorizing the agent for presenting the document, for it is such a power of attorney which is referred to in Section 32C. It is in regard to a power of attorney holder who is authorized to present the document for registration to whom Section 33 would apply. In the facts of this case, the second defendant was armed with a power of attorney dated 28/1/1987 and if it was not cancelled and he had executed the sale deed on 28/4/1987, he would be well within his rights to present the document for registration under section 32A of the Registration Act. The second defendant having presented the sale deed as executed, the presentation and registration cannot be questioned. Section 32C of the Registration Act, read with Section 33 and Section 34 2C, are interrelated, and they would have no application in regard to the document presented for registration by a power of attorney holder who is also the executant of the document. In other words, there is really no need for the protection of the original power of attorney when the document is presented for registration by the person standing in the shoes of the second defendant in this case, as he would be covered by the provisions of section 32A of the Registration Act, as he has executed the document though on the strength of the power of attorney. To make it even further clear, the inquiry contemplated under the Registration Act cannot extend to question as to whether the person who executed the document in his capacity as the power of attorney holder of the principal was indeed having a valid power of attorney or not to execute the document or not. On an analysis of the provisions, this court has no hesitation in rejecting the argument of the plaintiff that the non-production of the original power of attorney by the second defendant was fatal to a valid registration being effected. The understanding of the courts regarding Section 18A of the Registration Act is also erroneous. The trial court was right when it held that Section 18A of Registration Act is concerned only with the document which is presented for registration. The trial court clearly erred, relying upon Section 18A of the Registration Act to hold that certified copy, however being produced, of the power of attorney was in conformity with Section 18A, and the High Court was equally in error to hold that Section 18A of the Registration Act contemplated protection of a true copy of the power of attorney. The protection of the original power of attorney before the registering authority was unnecessary for effecting registration of the sale deed. The case set up by the plaintiff was that on the second defendant handing over the power of attorney to the plaintiff, the special power of attorney was deemed to have been cancelled in the eye of the law. There is no whisper in the plaint about the plaintiff having cancelled it in the manner in which he has deposed to in the evidence, proceeding on the basis that the second defendant had a duty to not sell the property below rupees 55,000 in terms of P1. The breach of duty to not sell below rupees 55,000 when the second defendant sold the property for rupees 30,000 cannot invalidate the sale or render it null and void. A perusal of the power of attorney will make it clear that any restriction on the price is conspicuous by its absence in the power of attorney. Therefore, the impugned judgment cannot be sustained. Friends, to conclude, in this video we have seen that the production of the original power of attorney is not necessary if the document is presented for registration by the power of attorney holder who executed the document on the strength of it, as per Amar Nath versus Gian Chand Anr case. In the next video I will see you with yet another case synopsis. Until then, I take leave of you. Bye.